Hi guys, welcome to our channel. I started making a series of videos on Indian Penal Code 1860 recently and I've uploaded a few videos. So I hope that you saw those videos, and if not then please check them out. I request you to watch all the videos from our channel and also press the bell icon next to subscribe button to get all the updates on our upcoming videos. Also subscribe to our channel. Today this video is on chapter 4 of IPC, which covers section 76 to 106. Section 76 to 106 of this code is on general exceptions, which tells us about certain persons who are exempted from penal provisions of this code due to some circumstances or capacity as provided in this chapter in IPC. I hope this video will be helpful to you. Indian Penal Code 1860 Chapter 4 Sections 76 to 106 Part 2. In this video I am going to discuss provisions from section 82 to 84, and the remaining provisions from this chapter will be discussed in the upcoming videos. This video is part 2. Section 82. Act of child under 7 years of age. Nothing is an offence which is done by a child under 7 years of age. Explanation. It is very simply written that any act done by a child less than age of 7 years will not be considered as offence. Section 83. Act of a child above 7 and under 12 of immature understanding. Nothing is an offence which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. A child can commit no wrong. Number 1. If he is below 7 years of age, as he is at such age presumed to be not endowed with such sufficient maturity of understanding to be able to distinguish right from wrong. Or number 2, if he is above 7 years and below 12 but too weak in intellect to judge what is right or wrong. Section 82 says nothing is an offence which is done by a child under 7 years of age, and section 83 says nothing is an offence which is done by a child above 7 years of age and under 12 years who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Law of exemption from criminal liability in case of minors. These two sections lay down a rule which, owing to its origin in civil law, had long since become established in the criminal systems of all civilized countries. In English common law, a child below 7 years of age cannot be guilty of any criminal offence whatever may be evidence as to its possessing a guilty state of mind in the ordinary course of nature. A person of such age is absolutely incapable of distinguishing between right and wrong. He is absolutely doli incapax, deemed incapable of forming the intent to commit a crime or tort, especially by reason of age. Indian law on this point is the same. If a child is accused of an offence under the code, proof of the fact that he was at the time below 7 years of the age is ipso facto an answer to the prosecution. The privilege of a child aged between 10 to 14 is absolute under English law, while it is qualified in India. According to English law, an infant between the age of 10 and 14 years is presumed to be doli incapax. But under this code, if the accused is above 7 years of age and under 12, the incapacity to commit an offence only arises when the child has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct, and such non-attainment would have apparently to be specially pleaded and pursued like incapacity of a person who at the time of doing an act charged as an offence was alleged to have been unsound mind. Whether really the child in question possesses sufficient maturity of understanding is a matter to be inferred by the court from the facts and circumstances of the case. In England, it is a presumption of law regarding the sexual offences that a boy below 14 years cannot be guilty of rape. In India, however, the presumption of English law has no application, and therefore boy of 12 years may be convicted of attempt to commit rape. Any offence punishable under the code, including an offence punishable under section 408, can be committed by a person more than 12 years of age. Criminal liability is quite distinct from civil liability. A person may be criminally liable even though he may not be liable in a civil case. Illustrations. Number 1. A child of 9 years of age took a necklace valued at rupees 28 from another boy and immediately sold it to another for rupees 50. The child was discharged under this section, but the accused was convicted for receiving stolen property, for the court considered convict displaying sufficient intelligence to hold him guilty. Number 2. The accused, a girl of 10 years of age, a servant of the complainant, picked up his button worth 8 annas and gave it to her mother. She was convicted and sentenced to a month's imprisonment, but the High Court quashed the conviction, holding that there was no finding by the magistrate that the accused had attained maturity of understanding sufficient to judge the nature of her act. In Marsh vs. Loader, the defendant caught a child while stealing a piece of wood from his premises and gave into custody. Since the child was under the age of 7 years, he was discharged. In case of Krishna Bhagwan vs. State of Bihar, Patna High Court upheld that if a child who is accused of an offence during the trial has attained the age of 7 years, or at the time of decision the child has attained the age of 7 years, can be convicted if he is able to understand the nature of the offence. Burden of proof. The non-attainment of sufficient maturity of understanding would have to be specially pleaded and proved. The onus is on the person who claims and the benefit of the general exception to prove the circumstances and entitle him to exception. In other words, under section 83, maturity of understanding is to be presumed in the case of such children, unless the negative be proved by the defense, while under English law, in the case of a child between 10 to 14 years, incapacity to commit the crime is to be presumed unless the contrary be proved by the prosecution. Section 84. Act of a person of unsound mind. Nothing is an offence which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Act of a person of unsound mind. Insanity has received the attention of writers, jurists, and judges since very old days. The focus of attention has been to give or not to give immunity for criminal liability to insane persons. Britton, Fitzherbert, Coron, Coke-Hale, Hawken, and Blackstone are some of the prominent names who have expressed their views about insanity as a ground of exemption or otherwise for criminal responsibility. Various tests were laid down by the courts from time to time about the recognition of insanity as a defense under criminal law. The wild beast test in Beverley's case in 1603, good and evil test in Lord Ferrer's case in 1760, delusion test in Hatfield's case and in 1800, and right and wrong test in Oxford case in 1840 were propounded by the courts. These were followed by McNaughton's case in 1843, which has great bearing on the Indian law relating to unsoundness of mind as a defense under this section. McNaughton's case. In 1843, the accused McNaughton of Scotland killed Mr. Drummond, the private secretary of British Prime Minister Sir Robert Pell, believing under a mistake that he was killing the Prime Minister. He pleaded insanity and the House of Lords acquitted him of the murder. This generated a lot of public sentiment and debate, and the pressure was so much that ultimately the House of Lords had to constitute a special committee for its own judges to finalize the law relating to insanity. 5 questions were put to this committee of judges and their answers are known as McNaughton's rules. Question 1. What is the law respecting alleged crimes committed by persons affected with insane delusion in respect of one or more particular subjects or persons? Example: where at the time of commission of the alleged offence, the accused knew he was acting contrary to law, but did the act complained of with a view under the influence of insane delusion of redressing or avenging some supposed grievance or injury or of producing some supposed public benefit. Answer. Assuming that your lordship's inquiries are confined to those persons who labour under such partial delusions only and are not in other respects insane, we are of opinion that notwithstanding the accused did the act complained of with a view under the influence of insane delusion of redressing or revenging some supposed grievance or injury or of producing some public benefit, he is nevertheless punishable according to the nature of the crime committed if he knew at the time of committing such crime that he was acting contrary to law, by which expression we understand your lordship to mean the law of land. Question 2. What are the proper questions to be submitted to the jury where a person alleged to have affected with insane delusion respecting one or more particular subjects or persons is discharged with commission of a crime and insanity is set up as a defense? In what terms ought the question to be left to the jury as to prisoner's state of mind at the time when the act was committed? Answer. As these questions appear to us to be more conveniently answered together, we submit our opinion to be that jury ought to be told in all cases that every man is to be presumed sane and to possess sufficient degree of reason to be responsible for his crime until the contrary is proved to their satisfaction, and that to establish a defense on the ground of insanity it must be clearly proved that at the time of committing the act the accused was labouring under such defect of reason from disease of the mind as not to know the nature and the quality of the act he was doing, or if he did know it, that he did not know he was doing what was wrong. The mode of putting the latter part of the question to the jury on these occasions has generally been whether the accused at the time of doing the act knew the difference between right and wrong, which mode, though rarely if ever leading to any mistake with the jury, is not as we conceive so accurate when put generally and in abstract as when put with reference to the party's knowledge of the right and wrong in respect of the very act which he is charged. If the question were to be put as to the knowledge of the accused solely and exclusively with reference to the law of the land, it might tend to confound to the jury by inducing them to believe that the actual knowledge of the law of the land was essential in order to lead to a conviction, whereas the law is administered upon principle that everyone must be taken conclusively to know it without proof that he does not know it. If the accused was conscious that the act was one that he ought not to do, and if the act was at the same time contrary to the law of the land, he is punishable, and the usual course therefore has been to leave the question to the jury whether the accused had sufficient degree of reason to know that he was doing that act that was wrong, and this course we think is correct, accompanied with such observations and explanations as the circumstances of each particular case may require. Question 4. If a person under an insane delusion as to existing facts commit an offence in consequence thereof, is he thereby excused? Answer. The answer must of course depend on the nature of the delusion, but making the same assumption as we did before, namely that he labours under such partial delusion only and is not in other respects insane, we think he must be considered in the same situation as to responsibility as if facts with respect to which the delusion exists were real. For example, if under the influence of his delusion he supposes another man to be in the act of attempting to take away his life and he kills the man, as he supposes, in self-defense, he would be exempt from punishment. If his delusion was that the deceased had inflicted a serious injury to his character and fortune and he killed him in revenge for such supposed injury, he would be liable to punishment. Question 5. Can a medical man conversant with the disease of insanity, who never saw the prisoner previously to the trial but who was present during the whole trial at the examination of witness, be asked his opinion as to the state of the prisoner's mind at the time of the commission of the alleged crime, or his opinion whether the prisoner was conscious at the time of doing the act that he was acting contrary to law, or whether he was laboring under any and what delusion at the time. Answer. We think the medical man under the circumstances supposed cannot in strictness be asked his opinion in the above terms, because each of those questions involves the determination of the truth of the facts deposed, to which it is for the jury to decide, and the questions are not questions upon a mere fact of science, in which case such evidence is admissible, but there the facts are admitted and not disputed, and the question becomes substantially one of the science only. It may be convenient to allow the question to be put in that general form, though the same course be insisted on as a matter of right. Insanity and unsoundness of mind. It is clear that section 84 of the code is based on McNaughton's rules. However, instead of the word insanity, the makers of the code preferred the expression unsoundness of mind. This has been deliberately done. Insanity has a very limited scope, whereas unsoundness of mind covers as much wider area. Any kind of mental derangement caused by any reason whatever may be unsoundness of mind, but the same may not be insanity always. The framers of the code wish to give a very wide scope to unstable mind, while recognizing the non-composed menace, not of sound mind, concept as a defense under Indian criminal law. In view of the above expression, unsoundness of mind was preferred to insanity under this section. Essentials of the defense. The defense under this section requires the following elements to be established. Number 1, the accused was suffering from unsoundness of mind at the time of doing the act. Number 2, he was incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to law. The section makes it clear that the accused must be of unsound mind at the time of doing the act. His state of mind before or after the commission of crime is not important, except with a view to know if that can be known as to whether he was of unsound mind at the time he committed the offence. The degree or gravity of unsoundness must be such that at the time he did not know the nature of his act, or he did not know that his act was either wrong or contrary to law. For instance, while shooting a man dead, if the accused did not know because of unsoundness of mind that he was using a gun, he cannot be held responsible because he did not know the nature of his act. Supposing that while shooting the man dead, he did know that he was using the gun, but because of unsoundness of mind he thought that it was being attacked by a tiger, and to save himself he had to shoot at it. Even then the accused is not liable, because even though he did know the nature of his act, he did not know that his act was wrong or contrary to law. Delusion or hallucination. In Kanbi Kurji vs. State, the accused believed himself to be pure-blooded Suryavanshi Arjun of Mahabharat. He had cordial relationship with his family members. One day he killed his wife and the eldest son without any provocation. He then went to the Sarpanch of the village and, addressing him Bhishma Pitama, he told him that he had killed Bhangdi, means his wife, and Kama, meaning his son. The court held that he was suffering from unsoundness of mind at the time of committing the murders, and even though he knew the nature of his act at the time, he did not know that his acts were wrong or contrary to law, as he believed himself to be Arjun and therefore entitled to kill Bhangdi and Kama. He was acquitted of the charges. The accused in dream was commanded by someone in paradise to sacrifice his own 5-year-old son. Next morning, he took his son to the mosque and killed him. It was held that he was acting under delusion of dream at the time of the killing, and even though he knew the nature of his act,
and also that it was contrary to law. He did not know that it was wrong since he had been commanded by someone in paradise to do the act. He was held not guilty. Religious belief or superstition. Where the priest of a temple sacrificed a 5-month-old female child, and his defense was that he was not in his senses but was inspired, he was held guilty as he knew the nature of his act and also that his act was wrong and contrary to law. On the other hand, where the father sacrificed his son because after his birth a large amount of money had not befallen on him as he had supposedly believed, and as a protest against injustice done to him by his deity, he cut his own throat. He was held guilty as he knew the nature of his act and also that his act was wrong and contrary to law. The court also observed that he was ambitious of obtaining worldly benefits like wealth by the sacrifice, and such act could not be justified even if he may have believed that his dead son would come back to life. Where the accused killed his own son during the morning bhajans, the Supreme Court refused special leave to appeal on the ground that accused would not be protected by Section 84 of the Code. Belief of presence of evil spirit or ghost. Where the accused killed his wife under the belief that she was haunted by evil spirits who would leave her when she was dead, he was held guilty as he had knowledge of his act and he also knew that he was doing what was wrong and contrary to law. Periodic epilepsy, schizophrenia and the like. In Unneri Kannan versus State, the accused, who had been suffering from periodic epilepsy since childhood, attacked his defenseless mother with a billhook, wooden reaper and firewood stick, causing her death. The prosecution pleaded that the death had been caused because there were occasional quarrels between the accused and the deceased over the quality of food prepared and served by the mother. There was no attempt to escape, nor was there any attempt to conceal the crime. It was held that complete absence of motive or provocation, nature and multiplicity of weapons used, duration of the attack and the maniacal fury of the attacked, along with the subsequent conduct of the accused, prove that he was acting under an insane impulse. He was given the benefit under this section. In State versus Emerciano Limos, A and accused B were brothers and G was a neighbor and a distant relative. On the day of the incident, when A and his wife were away, B started throwing stones at A's house. When A's children got frightened and came out of the house, they were also attacked. When G came out, he was also attacked with a stick and his wife, after being beaten, died 5 days later. The other persons who assembled there subsequently and the police which reached there later were also attacked. The doctors pronounced in the court that the accused was suffering from schizophrenia. This section was held to be applicable. Unsoundness caused by intoxication. Voluntary intoxication is not a defense under section 85 and 86 of the code, but if continuous voluntary intoxication on the part of the accused over a long period of time affects the mind of an accused to such an extent that he becomes a person of unsound mind, then he is entitled to be protected under this section if he satisfies the court that because of the unsoundness of mind he did not know the nature of his act, or that he was doing what was either wrong or contrary to law. Factors proving unsoundness. Where the accused was described in the first information report as a lunatic, the witness corroborated the same. No motive could be proved against him, and after drowning the young girl in the pond, the accused ate and slept well. And on being asked about the missing child, his reply was that he had sent her to the god, and the accused was not examined medically. It was held that the accused was of unsound mind. In Niman Shah versus State of Madhya Pradesh, the accused committed gruesome murder of 2 ladies without any reason by cutting their heads by an axe. There was evidence on record that earlier also he had suffered from attacks of mental disorder. After the occurrence, the accused was saying that he was haunted by God and hence had cut the heads of the two ladies. The Madhya Pradesh High Court accepted the plea of insanity and directed that the accused be kept in mental hospital until cured.
Factors negating unsoundness. Where it was proved that the accused had some kind of mental abnormality, but there were other factors present, like when he was asked to open the door by the witness, he did not open the door and came out with spear in his hand. He was found sitting near the door of his house with a spear in his hand soon after the incident, and when the questions were put to him at the time of investigation, he gave no reply but protested when he was being taken into custody. These showed that his mind was working well and he was not of such unsound mind as not to know the nature of his act or that what he had done was wrong or contrary to law. In Hari Singh Gond vs. State of Madhya Pradesh, the Supreme Court held that the mere fact that an accused is coincited, odd, irascible, and his brain is not quite well alright, or that the physical and mental ailments from which he suffered had rendered his intellect weak and had affected his emotions and will, or that he had committed certain unusual acts in the past, or that he was liable to recurring fits of insanity at short intervals, or that he was subject to getting epileptic fits but there was nothing abnormal in his behavior, or that his behavior was queer, cannot be sufficient to attract application of section 84 of the code. Onus of proof. The onus of proving the case is always on the prosecution, and if it fails in its efforts, the accused has to be discharged whether he is able to prove the defense successfully or not. But when the prosecution proves the case beyond reasonable doubt, the accused, the onus of proof lies on him to prove that because of unsoundness of mind he was incapable of knowing the nature of his act at the time of the incident, or that at the time he did not know that his act was wrong or contrary to law. The accused, who was woodcutter, and his sister were in a marketplace when she went to a police station and complained about her brother's insanity. On her return, along with the police constable, she found that her brother had suddenly killed the deceased by beheading him as if cutting a log of wood. He tossed up the severed head a few times in the air, and then bringing it near the body chopped it off in such manner that the brain substance fell out. Then again tossed up the head. He put up no resistance at the time of his arrest. It was held that the onus of proof on the part of the accused had been sufficiently discharged. Insanity not presumed. Requirements of this section to be proved. Where a woman jumped into a well along with her children but was later rescued, and she voluntarily explained her conduct, which showed that her mental faculties were in order, it was held that she was not entitled to the benefit under this section. Where the accused murdered his wife and child, did not run away after the door was broken open, and no motive could be proved, that does not necessarily mean that he was of unsound mind at the time of commission of crime. Where the accused attacked his wife and child, causing injuries to them in protest against the frequent quarrels between him and his wife, as he did not do anything to earn his living, it was held that the section did not apply. Thank you for watching. Please like, comment and share the video. Also subscribe to our channel. Keep coming back. Thank you.